Hello and welcome to Module 5, Unit 6, and we're talking about the transfer of title today. And this is going to be very, very important in your real-world application to real estate professionalism. You're going to have to know when and where title is actually transferred, and you'll have to know some of these key terms and definitions throughout this chapter for your actual exam. Now, my name is Brennan Posen. Today we're going over just the transfer of title. And again, just like in every other module that we've covered so far, if you have any questions that come up and you're just really stumped by what something means, feel free to reach out to me via email, and we can set up potentially a one-on-one Zoom or come to one of my live office hours and share that with us. I'm sure as a group, if you have something that you're questioning, somebody else in the group has this same type of question. So without further ado, let's go ahead and jump into this chapter. And again, this is just a brief overview. I'm not teaching you the entire chapter because you will have already read through this and taken some of the courses or the quizzes and hopefully taken down your own notes and made your own kind of connections to the whole portion of this part of the law of real estate. So we're going to look at the different key terms down here that are really, really important, and kind of briefly go through this chapter. And the first thing we're going to talk about is voluntary alienation. But before we get into those, one of the first things you're going to see on this chapter is that bundle of rights. And remember, we covered that bundle of rights in the introduction to the real estate business. So if you're confused on the bundle of rights, go back through Unit 1, Introduction to the Real Estate Business, and that will go over those bundle of rights through. And if all of this stuff is not making any sense, you're probably moving through the course a little too quickly, and you'll want to slow down and go back through and reread and check out those different definitions, because all the definitions start fitting together piece by piece. And if you don't know the definitions or you don't know the alphabet soup, as I call it, it can start getting really confusing really, really fast. Now, voluntary alienation is just the legal term for the transfer of title during somebody's lifetime, the actual property owner. So when we go and sell our properties or we gift the property, that's technically voluntary alienation. Now, a really important thing to remember for real estate and a huge document that we need for real estate is the actual deed, the deed to the real property, the deed to that house that you're selling. And the deed shows who owns the rights and title to that real estate. And when it's transferred to somebody else, that is what they get the actual ownership forms with, is the deed. Now, the person who is transferring the property is the grantor, and the person who's receiving the property is the grantee. And anytime in real estate, at least for this course, that you see OR, it's the person that is giving that service or that item. And if you see EE, it's the person that's receiving that process or the item. So if you think about when we're leasing real estate, there's the lessor, the person that owns the property and they're giving that lease, and the lessee, and that's the person that's actually signing the lease, or a trustor or a trustee. Remember, the trustor is the person that made the trust, and the trustee is the person that's receiving the trust or in charge of that trust. So we see these little gray boxes are really, really good and really good, important to have in your notes. Anytime you see one of these or a chart, make sure you go through and put those in your notes somewhere that you can refer back to that when you're studying for those final exams. So remember, the grantor is the person that conveys that property, the grantee is the one that receives, and the deed is the instrument that actually conveys the property from one party to the other party. So when they sign that deed, that is when the new owner takes over the controlling interest in that property and the rights to that property. So just like I was telling you, OR versus EE, OR is the person giving, EE is the person receiving. So if we talk about a divides, The devisor is the person giving that right. The devisee is the person receiving it. The deed, we have grantor, grantee. Leases, we have lessor, lessee. Mortgage, we have mortgagor, the creditor, or the mortgagee. Option contracts, we have optionor, optionee, and it goes on and on and on. So anytime you see OR or EE, just start thinking in your brain which party is which. Now, this is very important to remember for the final exam. You're going to want to know the requirements to actually have a valid deed, because without a valid deed, we cannot transfer that rights to the property. So in order to have a valid deed, we have to have a grantor with legal competency. And for the purpose of real estate, we are assuming people are legally competent unless they have had a court order or a doctor say that they are no longer legally or mentally competent, in which case we might have to deal with a trustee or a power of attorney in their place. So, for instance, I've dealt with one in the past where I helped somebody who had an unfortunate case of dementia. And when we started the process, he was very clear and cognizant, and he went through all the doctors and he started putting his powers of attorneys in place before we actually went through any of the rest of the process. And then it got quickly worse over time. And then we had to go through and actually get his power of attorney to step in for him. But in order to have that power of attorney take place, we had to also have a doctor sign off that he was no longer mentally competent and could not legally make any more decisions on his own behalf. Also on the deed, we have to have a grantee named. We have to have somebody that we're granting that property to, which makes sense, right? We have to have some type of consideration, which is usually required for recording that actual deed. We have a granting clause, and then we have what's called a habendum clause. And a habendum clause defines the ownership rights that is received by that grantee. So if you're thinking about a lease, that habendum clause is going to be different than a purchase, right? Because it's going to have different ownership rights. In a lease, you don't own the full property, but you do have possession rights. In a sale, you own the entire property and you can do whatever you want with it as long as it abides by all legal terms and legal statuses around you. We always have to have a legal description and an accurate legal description on most of our documents that we deal with in real estate. It's on your listing agreement, it's on your purchase agreement, it's on the actual deed itself. And it's very, very important to double and triple check those legal descriptions so you're not accidentally selling the wrong parcel of land. There's a story a while back that I remember in, I believe it was Texas, and the broker sold a vacant piece of land and his clients were super happy and they started building a $1.2 million house. They got done with the actual building of the home. And then after a few months, they get a knock on the door and they answer the door and it's the actual property owner of the parcel that they built their home on. Turns out that the broker sold the wrong piece of land. It was actually the one right next door that should have been sold to those people based off the legal description that they found. But they didn't double check that legal description before they closed. So it was a very big contentious issue. It ended up with the people that built the home having to actually purchase that land from that gentleman. And then now they ended up with two pieces of land and they were out an additional $75,000. I believe it was around there for that land that they accidentally built on. So legal descriptions are incredibly important. We also have to have exceptions or reservations to convey that full title. We have to have notarization or acknowledgement of the signature of the grantor. So notarization, this is typically the only time we're going to be seeing that in real estate, unless we have to have some special situation. But like our purchase agreements and listing agreements are not notarized, but the actual deed is notarized. That's done and signed in person. So we can do a lot of things over the internet with electronic signatures now, but the actual signing of the deed is usually done in person at title, and that is notarized as well to say that this was the actual person signing. Then we have delivery of the deed and acceptance by the grantee. Now, this is extremely important. Delivery and acceptance. And those are two giant words in real estate that you want to remember. Because until we have delivery and acceptance, once we have acceptance, we have a contract. If we don't have acceptance, we don't have a contract. So up until the time that one party shows acceptance of that contract, we can rescind our original offer or counter offer or whatever legal document we sent over up until that point. So acceptance is very, very, very crucial in our industry. Now, we already talked about grantor and grantee. Consideration is just a fancy word of saying that they've received something in return for the deeding of that property. So it could be a monetary amount. It could be something else that they worked out. It could be the actual purchase price of the home, or if you're granting it to somebody in your family, maybe it was a $10 thing of consideration. Now, the granting clause is just a fancy word of saying that the grantor intends to convey the property to the grantee. So don't get that too confused and think it's something totally different. The granting clause grants the grantee the right to the property. We talked about the habendum clause already. We talked about legal descriptions, and we have talked about signatures on that and acknowledgement, right? Acknowledgement is just a formal declaration that the person who signs a written document is doing that voluntarily, and that their signature is genuine. Remember, we can't have anybody in their not their in their right form of mind, and we can't have anybody coerced or held hostage or anything of that sort in order to sign these documents. Everything has to be on their own, voluntarily done, and it has to be their actual signature. Even when we send electronic signatures, that goes to different email addresses for each person, so we can ensure that that person is the one actually signing. Then when we get to closing, that's why it's really important to have the title person have some type of notary as well, and they make sure that the people signing are doing so on their own volition. Now remember, for the test, it's going to ask you when title is actually passed, and you'll have to know that title is said to pass only when a deed is delivered and accepted. If you see on the test just delivered, that's not the correct answer to choose. It's when it is delivered and accepted. We have to have acceptance of the deed. Now, these are some different types of deeds that we run into, and you do have to know the difference between these deeds, at least in a general sense. Remember, we're not giving people legal advice on how to take the deed for their property, but we have to know generally what the differences are to each deed. So we know a general warranty deed, I call that the golden ticket of deeds, because it gives the greatest protection to the buyer, because that grantor, remember the person that's granting the rights to that property, is legally bound by certain promises they've made. So they're saying, as long as I've owned this property, I know it's free and clear. These are the encumbrances or liens that I put on it, and they're going to be paid off at closing. And I've done some type of title search that I know the people before me also kept that property in good standings. So general warranty deed is the one you're going to see commonly between two private parties. And that's the one we want to try to get because there's those guarantees and assurances built into a general warranty deed. Now, one you'll see typically with like bank-owned homes is a special warranty deed. And a special warranty deed limits that defense from the grantor. They're saying that they're promising to defend the title for as long as they've owned the property, but they make no guarantees about what happened to the property before they owned it. And that makes sense for foreclosures, right? Because they've taken that property from that person, and they don't know if that person had some outstanding mechanics liens or something of that sort that would come up later in the future. And again, remember that these little gray boxes on each side are really, really good to keep for your notes and kind of give you different examples of what type of deed and what that deed gives. Now, the bargain and sale deed, that one contains absolutely no express warranties against any encumbrances, but it does imply is a big word there, that the grantor holds that title and possession of the property, and it usually states that person's or entity's name and the phrase it grants and or releases or grants, bargains and sells this property to the other. The warranty is not specifically stated. The grantee of that has very legal recourse if something pops up as a defect on title later. So bargain and sale deed, we typically don't want to use unless that person knows the property really, really well. Now, the final one that you kind of have to know is a quitclaim deed, and quitclaim deeds are also called the buddy deeds, because these provide the grantee with pretty much no protection of any deed. It says, I may or may not own the property. I don't really know what happened to that property before I owned it. I make no guarantees whatsoever, and I can quitclaim deed this over to you. Now, quitclaim deeds are typically used to cure defects in title, called clouds on title. So like if we misspelled a name on a warranty deed filed in the general public, we would use a quitclaim to correct that spelling. I've also seen quitclaim deeds used for inheritances, people adding their children on, people adding their spouses on, and things of that sort. So we don't want to typically use a quitclaim deed unless we absolutely have to, or it's a situation in which case two parties have known each other for a while. Another one to remember is deed of trust. That just means the trustor is conveying the real estate to a trustee for the benefit of a beneficiary. So anytime you hear about trust or deed of trust, remember that is when the trustor is giving that deed of trust to the trustee for the beneficiary of that estate. Now, reconveyance deeds are used by trustees to return that title to the trustor. So when a loan secured by a deed of trust has been completely fully paid, then the beneficiary notifies that trustee, and the trustee conveys the property back to the trustor. So this is typically used in states where the mortgage creates a lien on the property, and instead of getting the actual deed to the property, the lender or the loan company would have that reconveyance deed in the place of the actual property owner. And once they pay off that home, then the actual owner will get the full deed to the property. Trustee's deed is really easy to remember. It's just a deed executed by a trustee. And then we have some that are executed by court orders. And remember, in real estate, if we have a court order to do something, that's the way it's going to get done. Okay, the courts are always right in this case, and they are going to give ultimate power to transfer and change real estate, or to release things, or to perform on contracts, or whatever damages might come up through that sort. So remember, courts have the final say in real estate if needed. Excuse me. Now, we also might see things like transfer tax stamps. Anytime you see a certain type of stamp, like documentary stamp tax, that is just another fancy word for transfer taxes. And that means anytime that we transfer real estate, that tax is going to be payable to the state. So when we record a new deed or a deed transfer, there could be a transfer tax on that. This is very common in some areas like California, and states like that. New York has transfer taxes. California has transfer taxes. Right now, New Mexico does not have a full transfer tax, but we could, in the near future, get some transfer taxes on. This is an example of how they do the math on some of those transfer taxes. Again, those little gray boxes are always good to pay special attention to. Now this goes over some involuntary transfers of real estate, in which case you would think of the property being taken by some other entity, right? We have different types of involuntary transfer. One that we've talked about before is the escheat process, in which case the state or county is taking the property back because that person died without a will and they can't find any heirs. And remember, without a will is intestate, with a will is testate. Now, we've talked about condemnation. Remember, condemnation is another fancy word for the suit that is used for eminent domain. So if that land is needed for public use, then the government can come and take over that property or a portion of that property. Now we have another very common one called foreclosure. And you guys have probably heard of the foreclosures before, the foreclosure process. And that just means that somebody has not paid up on their mortgage note, and the lender or the bank is going to come back through and foreclose on the property and take it back through that process of foreclosure. So they're actually going to go through the courts and take the property back legally, because they have the lien on that property, and you made a deal with them saying, as long as I pay my mortgage, I get to live in and own this property. Then our last one is adverse possession. And adverse possession, just like prescription easements or easement by prescriptions, need to be open, notorious, continuous, and hostile, right? So there has to be clear, continuous use of that property for a prescribed period. And each state's going to have different periods of time that somebody has to be in the property for that. But if they've been in that property in a clear, continuous, notorious manner for that set amount of time, then they could sue for adverse possession, and the squatter or the person that moved into that property and abided by all of these terms would then become the adverse possessor. Okay, so when we see adverse possession, think of maybe squatters moving in and having open, notorious, continuous, hostile, and adverse use of the property for whatever that prescribed period of time is. And we've already talked about testate and intestate and transfers of title by will, but one thing I did want to point out to is a devise, because we've talked about that just briefly earlier. And all you have to know is that the gift of real property by the will. So if we have a will and we're following the will, then that would be the devise. And remember, there's a devisor and the devisee. Person giving is the devisor, person receiving it is the devisee, and the devise is just making sure that we're transferring that property with the terms of the will. Now, in order to have a will, we do have some legal requirements, and you do need to know some of those legal requirements for the test. You have to know that they're of sound mind, so they have to demonstrate that they have sufficient mental capacity to understand everything that they are doing. Typically, it has to be a voluntary act free of any undue influence by anybody. And it has to be written and signed by its testator, so the person creating the will, before at least two, sometimes more witnesses, and they also have to sign that document. The witnesses should not be individuals who are named in the will as recipients, but some states also recognize oral wills or entirely holographic or handwritten wills. Some don't permit those, though, and they do require them to be written and signed by those witnesses. Now, if we have oral wills, that's a non-cupative, and handwritten is holographic. It's not like Star Wars, where we have a holograph come up and tell you the whole will. Holographic just means that it was handwritten. And you do have to know for the test that the non-cupative and the holographic are not recognized in all states. Now, if we have no will, if we have an intestate thing, and we are going to see how property passes, they go through the laws of descent. And these are how we figure out the laws of descent, right? So if we're married, it goes to the surviving spouse typically. If we're married and we have a surviving spouse, it would go to them, and then it would go to the children. So they would kind of split those proceeds 50% to the spouse, 50% by the children. And remember, this is intestate. So somebody didn't do a will. So we have to go through typically a court process or probate, and they decide how these things are distributed through the laws of descent. So let's say I am married and my spouse is not around, but we have children. The children would share that equally through the laws of descent and so on and so on. But again, remember, if we have no relatives and no heirs, then we would have that escheat process back to the state that that property is in. Now, I know I've mentioned probate quite a few times. This is the actual process of probate and what it means. But probate is a formal judicial, sorry. It's a formal judicial process, in which case the people that are benefiting from the property or think they're entitled to the property will go through the courts, and the courts will decide how all the documents are probated. So sometimes even if you have a will, we will have to prove the validity of the will, especially if somebody contends it, right? If somebody contends that will, you're definitely ending up in probate. Now that brings us to the key point review. And I've told you in previous modules before, these key point reviews are really, really important to show you the definitions and the vocab words that you're going to need for the test. So anytime you see these blue vocab words, I would personally go through and do some vocab charts or some vocab flashcards for these and get those types of vocab in my brain before I'm moving on to the next section. Because again, these vocab words start building off of each other and they assume that you remember exactly what the last previous vocab words were for that previous module, and then they'll start piling them on with new vocab words for the next module. Now, if you have any questions that have come up that I didn't answer in this little video, please feel free to send me an email and we'll set something up one-on-one, or come to my open office hours and I'm happy to answer questions there. They're typically on Wednesdays, and that information can be found in your class resources. Thank you for listening, and we'll see you on the next module. I hope you have a great rest of your day.